I thought. Yes, that's the wall.
The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning to all of those in the courtroom, as well as to those who might be watching by live stream. We have one case on our 10:30 docket this morning. We'll point out we do have a rather short bench today. So Justice Wilson is not hearing any cases on this week's docket. And on this particular matter, Justice Wall has recused. So we will be proceeding with those you see. For those who are not familiar with processes, by Justice Wall's recusal and Justice Wilson's non-participation means that they are not only absent for this oral argument, but they will also not be participating in any part of the decision-making process. So at this time, I will call case number 127835 in the matter of Suzanne Valdez, original action and discipline, and would ask counsel to please come forward and enter your appearances.
May it please the court, Kimberly Boniface. I'm the special prosecutor and I'm ready for argument.
May it please the court. I'm Steve Angermeyer from Southeast Kansas. I represent Suzanne Valdez. We are present and ready for argument, and I'd like to introduce Suzanne, and she will be addressing the court today as well.
All right, thank you. Ms. Boniface, you may begin.
May it please the court, I'm Kimberly Boniface and I appear as the special prosecutor. Madam Chief Justice, I request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Thank you. This is an original proceeding in attorney discipline involving the respondent Suzanne Valdez, an attorney admitted to practice in law in the state of Kansas in 1996. This comes before the court after an evidentiary hearing held in December of 2023, and a final hearing report was issued on April 22nd of 2024. What's significant today is that all 95 paragraphs of the findings of fact and conclusions of law in the final hearing report are deemed admitted pursuant to Supreme Court Rule 228, except for 2, which are simply the recommended discipline. Those were paragraphs 93 and 95.
Counsel, let me just interrupt real quick. Would you agree that even though the conclusions of law are deemed to be admitted, that we still have de novo review over those conclusions?
I don't know the answer to that.
Okay.
The only disputed fact now is the discipline. All findings of fact, which were 72, it was voluminous, are admitted, and the 2 rule violations were also admitted.
Got a question there. For the life of me, I could not figure out how many meetings there were between the district attorney's office under Ms. Valdez and the court. My notes have one on February 24, 2021, and another on March 5th. But then there's a reference in the panel report about a second March meeting. Are there 3 meetings between I'm going to call it the Valdez District Attorney Office and the court about this? Because I got confused.
I believe you're correct. There are only 2.
I think there might be a typo in one place where there's a reference to a March 4, or I assumed it was perhaps a typo in something, and I can't remember whether it was the final hearing report that used that or a brief, but there was a difference by a day on one.
And I believe it was on March 5th.
Okay.
The 2 violations were unanimously found by the hearing panel, which were the following. Number 1, a violation of 3.5D, when the respondent engaged in undignified and discourteous conduct degrading to the chief judge and the legal system, with a press release calling the judge's credibility into question. This is Special Prosecutors Exhibit 6. This was a public press release. It included the following two provisions. First, Chief Justice Judge McCabria has misrepresented my communications with him. It also ended with, unfortunately, this is yet another example of how an outspoken and honest woman is mischaracterized as untruthful by a male in power. The second violation was also a 3.5D when she engaged in undignified and discourteous conduct by making a social media post about an insecure man that was clearly directed at the chief judge. This is Special Prosecutors Exhibit number 9, and it was a Facebook post. It said, women of the world, I'm sorry.
Go ahead.
Women of the world, be prepared. If you are hardworking, outspoken, honest, and in a position of authority, the insecure man, all in caps, will try to tear you down. Not me, says I. She wrote this on a public account, sharing an article that was titled, Her Response to Chief Judge McCabria's Statement. There were two important things to note in the hearing report about these violations. The first was the context. The hearing panel noted that the respondents' comments about Judge McCabria were not made in the course of a zealous attorney making a point to a judge about a factual finding or a ruling in a case. Rather, they were personal comments and attacks that would be inappropriate even in a closed-door meeting with a judge. Second, they noted her disregard for the public and stated that undignified and discourteous comments were made in the public. They were published in a newspaper and placed on a public account of social media. And the respondent exhibited a reckless disregard for the negative impact that her comments would have on others in the judicial system.
To that end, oh, I'm sorry.
Well, so given that those are the facts, and you're the one who charged this, and I think also given the fact that everybody seems to concede these comments which suit the non-profession, those aren't my words, that everybody's been using. Explain to me why 3.5 sub D applies to these facts.
Because 3.5D is that a lawyer shall not engage in undignified or discourteous conduct degrading to a tribunal.
And how are these comments directed to the tribunal? I guess is what I'm struggling with.
I believe they were directed both towards Judge McCabria, who was the chief judge, but also this isn't a case where it's one judge and one attorney. He was a spokesperson on behalf of the Douglas County bench. And so it was directed towards him, but it also reflected on the entire bench.
But when I look at the case law that applies, the more recent case law that applies 3.5B, the comments that are at issue, even if they're sort of off campus, in other words, they weren't in the courtroom, are still directed at the adjudicative process. And these comments, are more personally directed to the judge as opposed to the adjudicative process. And so I think there's a disconnect between you're the one who charged it this way. So explain to me how these facts apply to a criticism of the adjudicative process here, or can we just concede that there isn't?
I believe it does apply to the tribunal. And I believe the case law is that an attorney is an attorney who is under our Kansas rules of professional conduct, whether you are in a courtroom before a judge on a case or whether you're at home sitting on your couch scrolling on Facebook. She had to follow the rules, whether she was in each instance.
Well, again, you didn't charge a violation under 8.2 or 8.4.
Correct, I did,
Or you charge it.
but the panel, the hearing
We
panel
don't have that in
found,
front of us is my point.
right, I had one before under 8.
But what we're left with is 3.5D and
And they found both to be under 3.5D.
If I could I'll try to articulate my question well. I want to take a little bit of a step back. Since this rule is, the purpose of the rule has to do with, big ideas like maintaining the integrity and legitimacy of the judicial branch and so on. Let's just stipulate for the purpose of my question that these were comments directed at a tribunal, and also that they were stupid, foolish, unprofessional, whatever adjective you want to use. Does it really serve the legitimacy and integrity of the judicial branch to punish speech that we find offensive?
I think if it is a violation of the Kansas rules of professional conduct, which it was found to be in this case, then yes, that's the job of this court. It's not, the media can have their own take on it and write whatever they want. And we as individuals can say what we want.
Well, I
government-
appreciate that you have a job to do and your job is to argue for the violations. So you may not want to answer it, but it just strikes me that we potentially do more harm than good when we punish speech, especially speech in this context that is being made by an elected public official in a dispute with another public official over what we can all agree was a very difficult try. I mean, if they're arguing about COVID policy. I worry about that. I just wanted to get your response if you have one.
And I think that comes down to, there are certainly ways that a lawyer can criticize a judge and exercise that speech. That wasn't done in this case. The level of speech that she had, and I know this court has outlined kind of the different rules of what we should do when we are criticizing a court. And you must be certain of the merit of the complaint. You have to use appropriate language, and you have to avoid petty criticisms. That didn't happen here. She, number one, did petty criticisms, name calling on social media, calling the judge an insecure man.
I agree. That is what our case law says.
The second,
Do you stand? I mean, you obviously are relying on that case law.
Correct.
Is
the Johnson case, yes, that
that
kind of
wise?
outlines what we have to
we
do.
punish petty criticisms. I mean, doesn't that make us look petty?
No, I think there has to be, I mean, we as lawyers trade, I guess, a part of our free speech for our law license, and we agreed to follow these rules. And so that is the decorum that is here. Another rule when we give our speech is we have to use appropriate language. And when she ends a press release with, "This is yet another example of how an outspoken and honest woman is mischaracterized as untruthful by a male in power." It had nothing to do with gender, and that language has no substantial purpose but to attack the tribunal. It wasn't, "Hey, I'm really worried about masks and here's why." It was name calling, and it was personal attacks. And that's where the court found that it was undignified, or sorry, the panel found that it was undignified personal attacks that would be inappropriate even during a closed door meeting with a judge.
How can the Johnson case survive First Amendment analysis, especially after Gentile versus State Bar of Nevada, where the Supreme Court said disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment? And I can see where we get to, and our more recent case law, that's why I was hedging my earlier question, but I can see where we can get involved when the lawyer is saying stupid and unprofessional things about the adjudicative process that they're in. And all of our post-gentile cases deal with that. Johnson just sort of sits out there, and I kind of think it's been abrogated by gentile. So I guess make the argument that the wider application to these facts to 3.5B is not violating the First Amendment.
I believe the case law is clear that the freedom of speech that we have as lawyers is not without limitation. And so I would say that our Kansas rules of professional conduct, if you violate those, that is the limitation.
Right, but the question is what's a violation? And this rule has to be interpreted in terms of being directed toward the tribunal, not just criticizing a judge.
Correct.
Even criticizing a judge in a stupid and unprofessional way. And all of our case law, like I say, our recent case law is aimed at trying to degrade some judicial proceeding that was part of the discussion. And to me, this is like the First Amendment cases involving student speech, where the government's interest applies, to on-campus speech that might be disruptive or whatever. But it's much, much more limited when you get off campus. And this is sort of, and in our case here is, in my view, kind of off campus. And again, what's the government interest in just preventing a lawyer from criticizing a judge?
I think the interest is in having there be, I mean, there's a public interest, certainly, of what did the public perceive? And they were harmed here. The context of how this happened was, as the court knows, there was protocols issued for COVID by this court for your plan. And Douglas County had made a plan under that, following this court's protocols. And one of the protocols was that the Douglas County was supposed to educate the public about what is the new, what have we done, and why. And so that was the purpose of the press release. We're letting the public know that we've been doing all of these things for their health and safety. And when that is met with the name calling and with remarks that have nothing to do with that, that does hurt the public interest. And I think that's what we're trying to, there's a certain level of decorum that we have to follow, whether we're in the courtroom or out. And I think that's the balancing test for the court.
What was the evidence that the public's interest was hurt, actually affected? I mean, it's sort of like claiming national security is involved in something. And I mean, the government's, and you're the government here. I mean, the government's got to come forward with something that puts that in play, as opposed to it just being rhetoric.
I believe the aggravating, like the judges who testified on the aggravating factors, the evidence was that, members of the public were appalled at what was going on. And I believe Judge Picorni testified, each member of the public doesn't exactly know what role the court has, or the chief judge has, or the district attorney. They see it all as a court. And so when they are scared about going to jury trials and they read a press release from the chief judge that they can go because it's safe, and then they read the next day from the district attorney that the chief judge is misrepresenting things and not telling the truth, and there are allegations, that might be their only context with the court, but they view that all as the court, and that's negative. And when you're trying to have the public feel safe, that had the adverse reaction.
So
Had Ms. Valdez expressed some real concerns about the plan and the safety perhaps not COVID safety, but just general safety. So if she had articulated those things, that also would have probably caused the public to question the chief judge's assessment that there was a safe plan in place. Would that have been out of bounds for her to have done?
Not necessarily if she had done it in the right way. I personally, what I think she should have done is, she knew about this plan at the end of October, and she's bringing this up now in March. And so she's had the plan all those months. I think she should have addressed it earlier, but if she hadn't, then I think the proper way to address it would have been to file a motion on the specific cases where you have those concerns.
And
to
wasn't she
articulate.
given the opportunity and expressed those concerns in both the February 24th and the March 5th meetings?
Yes,
It
she
seemed
was
like
given
that
the
was-
opportunity to, yes.
The complaint was she was told, but she was given a chance to express all of these concerns and did so.
Correct. And I think the judges said at the end of that second meeting, you haven't, Judge Hanley had been working on this for 9 months. She testified through the task force with you and through with Douglas County. And so she testified, I've worked on this for 9 months. You haven't brought up anything new in this meeting that isn't addressed in the Supreme Court protocols and in the Douglas County plan. But if you have any specific concerns following this, you can file a motion on those specific cases, and those concerns can be addressed by that judge. So you always have that option.
Wait, so are you saying that is what Judge Hanley said?
Yes.
Okay, do you know where it was at in her deposition or when she testified?
No, when she testified.
Okay.
In light of your last few answers, I want to try to explore what might the limits or the ramifications be of the rule that you're proposing we adopt. So if this court issues an opinion and a lawyer gets on Facebook and writes, that opinion is bogus, the court isn't following the law, they're just making it up. Does that violate the rule?
I think you would still have to be, because it's the law, be under the 3 rules of the Johnson and Eckelman's, which is you have to be certain of the merit, you have to use appropriate language, and you have to avoid petty criticisms.
Well, it strikes me that there's no possible way that that statement could not violate the rule, given the way you've prosecuted this case. I mean, what more damning statement could there possibly be of a court that they're not following the law and just making it up?
I think you would have to have a lawyer would have to articulate the basis and not just make it a petty criticism.
So it would be a violation of the rule.
I think it possibly could. It would depend, I think, on the context of what the lawyer included.
Okay.
I have a question. So it was something that you said earlier. Paragraph 74 of the final hearing report on page 16 notes that that respondent exhibited a reckless disregard, et cetera. And you said that. But then on page 81, the mental state is knowingly, as opposed to reckless disregard. And then when it cites on page 20, suspension is appropriate for knowingly and reprimand is appropriate for negligently, which is even different than recklessly. How do we reconcile all of this?
So this was tough. And this is on a consideration for discipline, obviously, is the ABA standards. And the mental state is a key factor. And in this case, the respondent's duty violated, mental state, and injury all match 7.2, which states that a suspension is appropriate when a lawyer knowingly engages in conduct that causes injury to the public for the legal system.
But that's not what the panel found as a finding of fact. Are you saying that we should,
That they did find, yes,
oh,
knowingly.
what paragraph is that? The word knowingly? Because I only saw the recklessly.
Um,
Oh, never mind. It's 81.
yes, and so this is the presumptive, and that is
Well, no,
what I
that's under-
followed with my recommendation at the trial. But what the panel did is they then
Okay.
picked a lesser standard and listed that 7.3. And I think, well, it doesn't say that they did, what I would say I think they did is the 7.2 is the presumptive standard. I think they listed and went lower because of the mitigating factors. And so they're showing maybe why they didn't follow the ABA standards.
You would agree that, again, I'm harping on this same point, but you would agree that Rule 3.5D does not refer to a judge, refers to a tribunal, right?
Correct, it does say that, yes,
And the rules define what a tribunal is, right?
correct.
And that definition is, quote, a court, an arbiter in a binding arbitration proceeding, or a legislative body, administrative agency, or other body acting in an adjudicative capacity. How is Judge McCabery operating in an adjudicative capacity in order to fall under that definition of tribunal?
I would say that I believe his press releases were not him personally on a case, but were on behalf of Douglas County Plan. So he was speaking on behalf of the entire bench or the court of this is our plan.
Does that make it an adjudicative capacity as opposed to just an administrative capacity?
I'd say because it still references how they're going to handle court proceedings. I think that would be the way that it would apply.
Is there any legal support for that position that you've just taken? Because I can't find any.
I'm not sure that I am aware of a 3.5D case that addresses what you've brought up.
Well, like I say, the case law post Gentile is always about the adjudicative process, regardless of whether the lawyer's in court pitching a fit or writing a letter in their office or, at home in their jammies on social. But the reference to the complaining words are about the adjudicative process that a court went through. And I don't see that tie there.
I'm not sure how to answer that. You're right. I mean, the rule is short and sweet and it doesn't go into that detail. And I'm not aware of a case.
And I
that
guess my
does.
point is, when I look at the more current case law, when it's always in that context of an adjudicative capacity, that sort of tells me that we're not straying beyond those kinds of facts. And the only outlier is Johnson. And like I say, I think Johnson's got some problems on a First Amendment basis.
Right,
It
and that he
sort of
was-
says you can't beat up on a judge anytime, anywhere.
Right, in the Johnson case, I know was outside of the process because he was sending letters out to other people claiming that judges were racketeering. So it wasn't in court, but it still was degrading to the tribunal.
Are there other questions? Thank you.
May it please the court. I'm Steve Angermeyer and I represent Suzanne Valdez. I'm going to give you a roadmap of kind of where we're going to go today. I'm going to speak for a few minutes. I'll answer your questions and then I'd like you to hear from Suzanne for a few. This case is about mitigation and the appropriate discipline. I can tell you that Suzanne and I,
Well, can we, this is about mitigation and proposed discipline. That's what you just said. We spent a lot of time backing up here and questioning the findings of facts and conclusions of law. You're not contesting that. Is that correct?
so.
I mean, we have our role to do what we do, but you're not contesting those findings and conclusions that there was a rule violation, 2 of them. Is that right?
That is correct. Suzanne and I discussed this at length. We actually argued about it. We had the First Amendment discussion over and over. We debated about the cases. We discussed them as well. And so this is the course we took, and we were looking at
And
it.
so that's the questions that council was asked. You're not really going down that road at all, as far as I can tell.
I can tell you we did not brief it. I can tell you that.
Well, you didn't contest it either.
We didn't contest it. We didn't brief it. We had a 3-day hearing with multiple violations, one of which was 8.2, which was very concerning to us. And so we were focused on trying to defend those allegations. When we got the opinion, we found we had 1 violation and the other 3 had been dismissed because there was no evidence to support that. And so it was a judgment call. And that's exactly what we did. We talked about it. We discussed it. We discussed the First Amendment issue over and over. We discussed whether it was even a 3.5 violation. And the concern was we didn't want the panel to go to an 8.2 violation. And so that was dismissed and we're left with a 3.5D violation. And that's essentially what we centered on. And that was the strategy we used, Your Honor.
I totally appreciate the position defense counsel's in when you're facing this kind of thing and you have to make strategic decisions. And I think that's essentially what you're saying. But let me, since you're up here, let me go ahead and ask you about some of the similar questions. And I guess my one question is, if the conduct of your client here is a violation of 3.5D, wouldn't my hypothetical earlier about a lawyer posting on Facebook about how a decision of this court is outside the law, essentially, wouldn't that also be a violation of 3.5?
It potentially could be. I can say that I wouldn't do it. And I wouldn't advise any other lawyer to do it. I do know this, when you take the oath, your free speech rights are somewhat limited and there's case law to support that. You can't just go into a Walmart and do certain things. Our behavior is limited as a lawyer. We're held to a higher standard. And so that's why we're here today. The thorny question.
Just going to his question, what about if you are a lawyer and you wrote a law review article talking about, the same thing that he's saying, which there are, I would guess, thousands of law review articles about there, even about our cases, criticizing the legal basis, saying that, the justices went too far. They didn't follow the law. I mean, wouldn't that be a violation?
I don't think it probably would be, and I don't think you could probably prosecute it.
What's the difference between that and a Facebook post?
Well, it's a fine line. We know that the Facebook posts are proliferate and instant. The panel found that and I got to be careful here. I don't want to argue for the prosecution, but the panel found that it was directed specifically at Judge McCabery. And so that's where they found the violation.
Isn't this the problem with, I'll use your words, policing fine lines when it comes to speech?
Yes.
I mean, don't we know by experience that this is a fool's game?
Yes, it is.
Okay.
Well, can I go back here? Some of these hypotheticals are taken completely out of context for what we're dealing with in 2020, 2021, and 2022. We were in a public health crisis. We were struggling with how are we going to proceed with protecting constitutional rights, proceeding with jury trials, the gamut of that statewide. Each district was coming up with different plans that we were trying to encourage, support, and that's what was going on in the 7th Judicial District. They'd spent months developing a plan with input from all of the people involved, and each district did different things. And the seventh chose to have a different environment that was more conducive to public spacing, all of the concerns that were there at the time. We seem to be forgetting about that. And the notion that this wasn't a part of an adjudicative process, when that was the whole point of setting up alternative venues for proceeding with trials, for proceeding with justice in the state of Kansas. And this is getting lost in a lot of our discussion here this morning of what was going on at the time. There was a lot of pressure to proceed, and each judicial district was doing their most conscientious efforts in attempting to meet all of these needs. And I think that's what was going on also in the seventh judicial district. Would you agree with that? That's that's where we were at the time. And I guess I don't understand if that isn't a part of the role of the judges of the legal community in Douglas County, why that doesn't encompass the whole notion that this was an adjudicated process that was being developed.
It's again, fine line, Your Honor, and you'll have to define that. Typically, we want to go right to a case. We talk about an adjudicative process.
I understand that, but these are unique times, and hindsight's great. But when we were in the throngs of that stuff, we were desperate to try to get just the process going to meet all of the needs of both prosecutors' offices, of defense counsel in criminal cases, and just all cases.
Yeah, I agree. It was a difficult time, and we pointed that out in the brief. I would point out that Ms. Valdez, Suzanne, did not have a voice in that plan. It was done before she entered office.
Well, she wasn't in office,
right?
But she had opportunity to participate in those things in the fall, and then there were meetings in February and March in which she could participate, and apparently did.
She did.
She did, correct.
She did in the spring. She had limited participation with the plan, and the jury.
Well, it had been developed because that's what was happening in the months prior to, and the prior district attorney, who had vast experience in prosecuting cases, understood safety concerns, apparently was involved and approved the plan.
He did, but you have to remember, the prior prosecuting attorney absolutely refused to talk to Suzanne. He just shared nothing with her, and it was desperate. As a matter of fact, she had no access to files, no access to thumb drives. She had no access to employees. She had to meet with them secretly at the court to even talk to them. And she had jury trials set the day she entered office. It was a very difficult situation for her.
It seems to me the answer to that, seems to me the answer to that is then take it out on him and not Judge McCabery, who's trying to deal with a difficult situation.
I think
That's why it underscores how stupid and unprofessional these comments were.
She readily admits that, Your Honor. She readily admits that. She admitted that at the hearing. She'll admit that to you today. You'll see that in the record. Clearly, the comments were intemperate, and that she characterized them as stupid, and they should not have been made. The difficult circumstances, though, the panel found in two different instances. If you'll look at paragraph 91 and 95, the panel found the difficult circumstances we were just discussing to be a contributing factor, at least having something to do with it, to put it in context. Does it excuse the behavior? They didn't say that, and we're not saying that. But at least it lets the court understand where we were coming from at the time. And so those difficult circumstances were, of course, COVID was in full swing, very limited vaccinations, very limited staff. As I indicated, no access to any files, none. No input on the jury COVID plan or the jury trial schedule. She had no input on it. She could have attended, but she had no input on it because she wasn't the DA. And the emails that were sent to Mr. Branson and not to Ms. Valdez. That's important to understand. She was not privy to any of those emails. So, and she had to issue subpoenas for people on the first day of office who were potentially jurors or jury pool members or sheriffs, and COVID was in full swing and they were not coming. She didn't have employees coming in. She was a new DA and she was learning a new computer system. we believe there's significant mitigation here. If you find a violation, we think there's significant mitigation here. She apologized. She showed remorse. She attempted to apologize to the judges several times. She testified this was out of character for her. She was frustrated by her reaction, and she testified to that. She's disappointed she came to the hearing, and she's disappointed she's here. She apologized to her staff at a staff meeting. She apologized to Judge Kevin Moriarty, who was the Douglas County mediation judge twice. She apologized to the hearing. She's embarrassed and pained to be here, and she will apologize to this court.
Can you
There's a-
explain to me?
Yes, sir.
In your mind, what's the difference between a published Supreme Court opinion that at the end says we're giving you an informal admonition and a published Supreme Court opinion that says this is public censure?
Well, Suzanne and I debated that as well. And she desired to have informal admonition. She believes that her record, well, it was clean. There's no prior record. And she wants her record to remain as stain-free as possible. And so even though an informal admonition will be potentially the result, she requests the court issue an informal admonition in this case. And so, yes, it still would be put in the reporters, but she is requesting that that occur. I would also point out that there was significant delay in this case. The gray letter came on March 26, 2021. The complaint was filed almost over 2 years later on August 14, 2023. Today is April 1st, 2025. It's 4 years and 6 days. It's a long time. She showed remorse. I see I'm running low on time, and I want Suzanne to speak, and I want you to hear from her because I don't want to run out of time without letting her speak. I have a few other things to say, but Suzanne, would you kind of come up and address the court, please?
May it please the court. I've argued in front of this court before. My name is Suzanne Valdez. And I want to sincerely apologize to the court for having to be here today. I want to thank Steve Angermeyer, who has been a steady and capable advocate. He's been even-tempered and diligent, and I appreciate your wise counsel. I also want to thank many of my former law students, friends, my family, and members of the public who did support me throughout this personal and professional ordeal that I've been experiencing for the last 4 years. And for all those people who wrote letters of support for me, I thank them as well. I am here to give you my authentic apology. Never in my craziest of nightmares did I ever believe I would be standing in front of this court at a disciplinary hearing involving myself. My entire life, I have followed the rules and decorum, and I have remained true to the rule of law, even when I questioned it. And as a woman and person of color, I have questioned the rule of law many times. But as a law professor at KU Law School for 21 years, I stress to my students the importance of the rule of law and their ethical responsibilities to uphold it. As a Hispanic girl growing up, I worked very hard to achieve what I achieved in my lifetime. So, excuse me, I grew up in a blue-collar family. I am one of very few in my very large extended family. I have 7 aunts and uncles on one side, 6 on the other, with tons of cousins who I grew up with. And I am certainly the only one with a college degree, and certainly one with a law degree. I never knew a lawyer before I grew up. Before I started law school, I should say. I'm sorry. My entire professional life as an attorney for the almost 30 years has been one of public service. I started my career in Kansas City, Kansas, the DOT in 1996, working for Kansas Legal Services, doing domestic violence work, Social Security hearings for the indigent and disabled, and lots of landlord-tenant litigation. I then taught at the KU Law School for 21 years, starting in 1999, where I was able to mentor and teach students on the ethical practice of law in my clinical work, and by being instrumental in developing the KU Law School's practical skills curriculum. I'm very proud of the programming that I started there During my tenure as a faculty member over many years, law students and the entire KU KU students confided in me many times about being sexually assaulted. I listened to them and believed their experiences, and I supported them in all ways possible. I advised them about the cruel treatment of the university Title IX and criminal justice system processes. Today, sadly, very little has changed. I've worked in private practice. I worked as a special prosecutor in Wyandotte County and as a pro tem judge in district and then the 7th Judicial District, handling the juvenile offender docket for a time period. For 8 years, I served as chair of the Kansas Crime Victims Compensation Board, a statutory board which instilled in me how the criminal justice system often ignores the pain and trauma that victims and survivors endure. And lastly, I just want to share with you, and this is probably part of what I was so emotionally fragile at the time that this incident occurred. In 2019, my only sibling, my younger brother Christopher, a Gulf War veteran, died of a fentanyl poisoning in Maricopa County, Arizona. My family, his children, and I were completely devastated by his death, and we were shocked that law enforcement didn't conduct a criminal investigation into his death. This is all to say that all of this came together for me as I decided to pursue running for elected office as Douglas County District Attorney. I wanted to be a voice for victims and survivors, reduce the criminal justice footprint, and use alternatives to incarceration when appropriate. I was doing everything I could to keep my community safe. I've heard questions asked by the court to counsel, and I want to be clear that I was DA-elect in 2020 when the COVID jury trial plan at the fairgrounds was being created. Not once was I asked to be invited to the table to give my perspective, even informally. Mr. Branson, the DA at the time, never involved me. I didn't know anything that was going on, nor was I a part of that discussion. The jury trial plan and the schedule were set to go the day I was sworn into office, with 4 criminal jury trials set at the Douglas County Fairgrounds. Upon looking at that plan, I was in a state of just trying to get people hired. People were out sick. It was just a very, very chaotic time. And just to give you a sense of how enormously chaotic it was, there was at least a couple weeks when probably of the 17 prosecutors I had working for me, there were only 3 of us in the office, myself included, and I had 20 minutes to prepare for an off-grid Jessica's Law preliminary hearing. That's how crazy it was. Our phones were ringing off the hook with people saying, why do I have to go to jury service when I can't even go to the dentist? It was just, we were unvaccinated. There was all kinds of just chaos. The question has occurred, well, I had plenty of time to try to talk to the court. And to be honest with you, that reality isn't the reality. I was busy trying to move cases. I was busy trying to learn the system. I was busy trying to get people hired. Whether the jury trial plan involved the prior DA or not, I had no idea the extent to which that happened. All I know is that I was not included. And being a woman of color, being someone in my position, I believe that I should have a seat at the table. I was a chief law enforcement officer of the county, and I wanted to make sure our community was safe. So just to be clear, what led to this filing of Judge McKittrick's complaint was there was discussion about 2 meetings about this plan. The February 24th meeting wasn't really even a meeting about that. It was about something else. And it was in passing that Judge McCabery said, you guys got to be ready to go. That's when I started thinking, I've got to look at this plan. This is going to happen. That's when I was looking at the details. I took time to look at the details. And that's after we had an experience there where there was a violent offender for a pretrial hearing and our prosecutor came back absolutely terrified. I went back and looked and I thought there's so many questions here. And that's why I called the March 5th meeting with Judge McCabery and Judge Hanley, who were part of that plan. I asked really tough questions, Your Honors, Justices, like, this is a fairgrounds, this is an exhibit hall. Where are we going to sequester witnesses? How are we gonna make sure the jurors don't ensure that they don't know that this first degree murder, attempted first degree murder defendant who's violent in the jail, that he's properly secured? How are we gonna make sure that the jurors don't know he's in custody? There were so many different questions that I was asking that there weren't any answers for. I asked for the security plan. There was no security plan. I contacted the sheriff immediately and asked him to do a security plan because this trial was gonna go. I had people in my office saying they didn't want to try it. So I prepared and I tried it along with my then deputy district attorney, Joshua Seiden. What led to this was I thought we were going to have more discussion about this with the court. Instead, they issued the press release, and that press release is clear. My name is not on there because I was never consulted about any plan. And there's confusion. There's perceptions about, all of whether, I should have known or I could have asked questions. Yeah, this is all hindsight's 2020. And I would do all of this all over again, but I assure you that when I saw that press release, I needed the public to know that I had no part in this. They were going to hold me responsible as the elected district attorney. And I wanted to make sure they understood that. Then Judge McCabery issued a second press release. And then, of course, I responded in kind. And that is where I should have taken the high road. And I apologize for that. It was petty. It was just completely out of character for me. And this is a result when there's no communication. When communication happens, you can disagree and you can go forward and hopefully move on. This was extrajudicial in nature. I apologize. I try to apologize many times and the court declined. I asked to do mediation and they declined. Our county administrator even asked, she said, let's just get this cleared up. This isn't good. I said, I agree. She asked on our behalf and Judge McCabery declined. I sent an email to him asking for restorative justice practices so that we could learn to communicate with a very good facilitator. He declined. I was left in with this process. That was my only way. And this has been going on for 4 years. I just want this over with. I want to move on. And I ran for re-election. And what I heard from voters was just this, that this process, this is harmful to the system. So I am sorry. I apologize. I made a grave mistake when I allowed myself in my frustration and the turmoil and COVID and all the anxiety and all of that to get the better of me. That's not who I am. I'm a very passionate person. I'm a very honest person. I am all those things. And I am sorry. So the last thing I will say to you is that I was so harmed by the prior DA administration's treatment of me and the transition that when I lost this election, I did the complete opposite. The minute the canvass occurred, I invited the new DA to the office. I gave him all the information he needed. I turned over everything he asked for to ensure that there was a smooth transition with the office. I am now in private practice. I continue my work advocating for victims, doing mediation and public work or public service for those marginalized communities who need my advocacy. So I would ask this court to consider all of that. And I thank you for your time.
Briefly, if I may.
Yes, you may.
Thank you. Want to address, just in closing, you have remorse, delay, no dishonest motive, previous good character, difficult circumstances. That's what you're facing. I would also request the cost. This was a 3-day trial. There were 14 prosecution witnesses. One was done twice for rebuttal and 2 defense witnesses. There were 4 counts defended, 3 were dismissed. And so if you see paragraphs 14, 78, and 94 of the hearing panel's decision, that's where they were dismissed. There's only 1 violation they found. So if the court does indeed find a violation and imposes punishment, we request some sort of pro rata consideration along those regards. Thank you.
You reserve 3 minutes.
Very briefly, Kimberly Boniface, Special Prosecutor. First, to follow up on your question earlier about Judge Hanley, that is located on volume 2, pages 159 and 160, where she testified there was nothing new brought up at the 2 meetings by Ms. Valdez that wasn't already in both the Supreme Court's plan and the Douglas County plan. She also testified that the security plan was done and that she had personally verified it. I'd also point out to the court that the hearing panel found in paragraph number 57 of the report that as of the hearing on this matter, which was 2 years and 9 months later, the respondent had still not apologized, notwithstanding the fact that she worked in the same building as Judge McCabria and that she had numerous professional interactions with him during the period of time. So while she apologized to the panel and to this court, there wasn't an apology to the judge who was affected. And then finally, I'd ask that the court consider, in this case, the public nature of the conduct. It underscores the benefit of a published court opinion and a published censure. So it will provide the public with a final and legal determination on the attorney misconduct. I'd also point out, as we discussed earlier, the standards. We've already deviated downward to give leniency for the mitigating standards. So I'd ask for a published censure. And finally, just in responding on the issue of cost, one of the largest costs that I would ask this court to consider was that the respondent believed there was a conflict or the respondent advised on the hearing panel that she was going to call their attorney as a witness and that she was going to call their attorney and also her husband. And so she listed those. And so there was a significant cost in then having to, at the last minute, hire a counsel to the board. And that was Randy Grizel, who did a wonderful job. And but that additional cost, she then didn't call the attorney, the panel's attorney, nor her husband. She'd also listed Ms. Larkin as a witness and didn't call her. So there was some cost that was caused, and I'd ask the court to consider that in your final verdict. Unless the court has other questions, I'll rest on my brief and ask the court to uphold the panel's findings of fact and conclusions and to impose discipline no less than the published censure.
I see no other questions. Thank you.
Thank you.
Thank you to all of you for your arguments and statements to the court today. The court will now take this matter under advisement. By that, I mean that the court will now begin discussing the resolution of this matter, and we will eventually arrive at a written decision or perhaps multiple decisions related to this. Those will then be filed with Mr. Shima's office, the clerk of the appellate court. They will also be posted on the KS Court's website as well as through other resources. When the court does issue opinions, usually on a Friday morning, there are also our press releases, a press release notifying the public about what opinions are being released that day. With that, the court is under